Good afternoon, and thank you for joining me for this webinar. My name is Laura Ensinger, and I'm a solicitor here at Michael Lynch Family Lawyers. For anyone who's not aware, we are a specialist family law firm that practices only in family law. We've been established for over 25 years. We currently have 15 lawyers, 5 of whom are accredited family law specialists. Here at Michael Lynch Family Lawyers, we assist our clients with all aspects of their family law issues in relation to advice, negotiation, mediation, and going to court if it comes to that. We offer a fixed cost initial interview where clients can come and meet with a solicitor to discuss their concerns and issues. We can provide advice about their situation and come up with a strategy for moving forward and an estimate on their likely costs. The scope of family law is fairly broad. As you can see, it covers a lot of different areas such as separation, divorce, parenting agreements for children, child support, spousal maintenance, domestic violence issues, international and interstate relocation, and finally property settlements. Brings us to the topic which I will be discussing today. Our presentation will be about property settlements, which are fundamentally for couples who are separating. We will talk about what actually is a property settlement, how do we assess what our clients' entitlements are, how do we help the parties to reach an agreement about property settlement, how do we then help parties to finalise that agreement, and some practical considerations of things that might help clients in getting started in the separation process. This presentation is really to assist accountants be aware of some issues and requirements that your clients may face as they're going through this separation process. It can be helpful to work closely with solicitors to ensure that your client's financial information is accurately and properly presented during this process. Understanding the Family Law Act's 5-step property division process will allow you to provide valuable assistance to your clients in navigating the financial implications and the effect of their property settlement. The first thing I want to talk about is what is a divorce. A divorce is a legal severance of the marriage. It is different from a property settlement. It's actually quite a straightforward process. In Australia, we have a no-fault jurisdiction. This means there's no need to prove any sort of issues like adultery, abandonment, or abuse. Once you've been separated for 12 months, the party can make an application for divorce. Parties don't actually need the consent of one another to proceed with the application. Now, what is a property settlement? It is a really complicated and multifaceted area, and each case is very different from the last. Essentially, the actual property settlement is the alteration of the parties' existing legal entitlements to property. So the parties will already own property, assets, liabilities, and their superannuation, etc. There are various ways to achieve a property settlement, and it is a question of whether that should be altered now that the parties have separated. It is important to understand that the aim of a property settlement is to sever the financial relationship between the spouses so far as possible. We call this the clean break principle, which is set out in Section 81 of the Family Law Act. Understandably, in some cases, there are issues relating to the ongoing joint ownership of assets and debts. This can lead to all sorts of issues and conflict down the track, particularly when separated couples are no longer in good terms. It's really important as far as possible to separate the financial affairs of the party. However, it's not always possible for this to occur immediately. For example, some people may continue running a business together for a period of time, or if there is, say, a property to the parties are not in a position to sell at the moment due to the market not being ideal. Therefore, the parties may wish to hang on to that property for a period of time. Then we want to make sure that any agreement covers all of the potential eventualities and consequences. When negotiating a property settlement, it is also important to understand that each party has an obligation of full and frank disclosure to the other party. That is disclosure of all of their relevant financial circumstances, and this usually includes exchanging documents. This is often when we might get the parties to contact their accountant to make sure that they have all of their relevant documents available. If the parties run a business or operate through a company, or if one person refuses to give that information, it is possible for one party to issue subpoenas for that material to be provided from a third party as well. We note that the court has the power to set aside financial property consent orders or a financial agreement if it can be proven that there has been a material non-disclosure of assets or fraud that constitutes a miscarriage of justice. This means that if a party discovers in the future that the other party has failed to disclose relevant documents or information, or has seriously misrepresented the nature or value of an asset in which they have an interest, or their respective current financial circumstances, that party can apply to have the consent orders or financial agreements set aside. It is therefore in each party's interest to ensure that they have made proper disclosure of all of their significant assets, liabilities, and financial resources with the documents that are in their possession, power, or control, and that a genuine and not misleading estimate of value is provided for each asset, liability, and financial resource. As I mentioned earlier, property settlements are available to de facto couples as well. Understandably, this is quite easy to determine with a married couple, provided you've got a marriage certificate. However, with a de facto relationship, it can become a bit unclear as to whether the parties are actually in a de facto relationship. A person is in a de facto relationship with another person if the persons are not legally married to each other and the persons are not related by family. And having regard to all of the circumstances of their relationship, they have a relationship as a couple living together on a genuine domestic basis. A de facto relationship can exist even if one of the parties is legally married to someone else or is in another de facto relationship. Apart from being in a de facto relationship, parties also have to meet some gateway criteria. One of the 4 gateway criteria to actually being able to bring an application for a property settlement, either the relationship needs to be for at least 2 years, there is a child of the relationship, either party has made substantial contributions to the relationship, for example, funds going into a property, or the relationship is registered. So first, let's dispel some of the myths about property settlements. There is no rule that parties get 50-50 if you are married. It is not the case of whatever you get out of the relationship is what you put into it. There is no requirement that everything gets sold upon separation. Whilst we sometimes discuss adjusting the ownership of assets, this does not mean that realistically people need to sell their assets. If one party can afford to keep their asset, then the court's preference, provided it is just and equitable, would be for that party to retain the asset. The time limit for applying for a property settlement, if you're married, is 1 year from the date the divorce order becomes operative. As I mentioned earlier, you cannot apply for a divorce order until you have been separated for 12 months. For de facto relationships, it is 2 years from the date of separation. That date is the time limit for applying to the court for a property settlement. However, parties can reach an agreement outside of that time period. However, this should be considered as a last resort, as we don't want parties to run out of time for their property settlement entitlements. If we are trying to negotiate a property settlement and a party is running out of time, we may consider filing an application with the court to preserve our client's rights to pursue the matter through court if they cannot reach an agreement in the meantime. So how do we actually work out what each party gets? This is not a mathematical exercise. The court has a very wide discretion. There is a series of factors that the court has to consider and weigh against each other and come to a result that is overall just and equitable. The first question we really have to consider is whether we actually should be doing a property settlement in the first place or altering the parties' existing property interests. Parties have separated, they need to go on their separate ways. However, the case of Stanford was an unusual one. In this particular case, it was an elderly couple in their second marriage, which had been a very long marriage. They wanted to stay married and intended to stay married. Parties can actually have a property settlement whilst continuing in a relationship. Again, this is unusual, however, it does happen on occasion. In this particular case, the wife was in an aged care facility and the husband remained in the home, which was in his surname. Both of the parties had actually lost capacity, so their respective children actually carried on the proceedings for them. In particular, the wife's adult daughters brought the application and took it all the way to the High Court for a property settlement. This would be because, reading between the lines, they essentially wanted to protect their future potential inheritance. The High Court decided that in this particular case, because the husband was paying for the wife's accommodation of the aged care facility, he would have to sell the house to give her a property settlement, which at that point she did not need. In this particular case, the court found that there should be no further adjustment or property settlement. The case was a bit of an outlier in terms of unusual circumstances, but perhaps something that we might see a bit more regularly with an ageing population and people's relationships. Leaving those kinds of exceptional cases aside, for most clients, it's not a contentious issue. So we go through the 4-step process to work out what their entitlements should be. Step 1, we determine what is in the asset pool. That is, all assets, liabilities, and superannuation in either party's name. Under this step, it is important to identify all interests in property that the parties have at the current date. It is important to remember that all interests and types of property must be identified and valued in this first step, regardless of when the property came into existence or how it came into existence. For example, money inherited by one party after separation will still need to be identified and valued and included in this first step. In this step, all assets and liabilities owned by both parties, either jointly or individually, are identified and valued. The court has the power under Section 79, subsection 1 of the Family Law Act to alter the parties' interests in all of their property, regardless of when it was acquired and regardless of which party's name it is owned. The identification and value of the parties' property is considered as one of the date of the final hearing or date of agreement. During this step, both parties are required to provide a complete and accurate list of the assets they own, both individually and jointly, as well as any liabilities or debts they have. The net asset pool is calculated by deducting the parties' debts from the value of their assets. Accountants can help their clients compile the necessary documents and present their financial information in a clear and organised manner. The accuracy of this step lays the groundwork for a just and equitable property division process moving forward. The starting point for most valuations is usually the current market value of those items. If the parties cannot reach an agreement on what the value should be, then we would get an independent value to make an assessment. There are several options parties can use to value real estate property, those being a professional valuation. The most accurate way to value real property is to engage a professional property valuer. These experts have knowledge and experience to assess the market value of property impartially. They consider various factors such as the property's location, size, condition, features, and recent sales of comparable properties in the area. The next option is a comparative market analysis or appraisal. A comparative market analysis is a less formal method of valuation often used by real estate agents. It involves analysing recent sales of similar properties in the same or similar neighbourhoods. Whilst not as precise as a professional valuation, it can provide a good estimate of the property's value. And last, an independent appraisal. In some cases, parties may agree to obtain independent appraisals from different real estate agents to estimate the value of the property. This approach can provide a range of options which can be helpful in negotiations. It is a good starting point for parties, particularly where the property pool is modest and the parties do not wish to pay for additional costs for a professional valuation. Understandably, property values can fluctuate based on the current market conditions, including supply and demand in the area. It's essential to consider the market context when valuing real property. Renovations, extensions, or other changes can impact the property's value. If the property has undergone significant updates or improvements, these should be considered when having the property valued. In some cases, the parties may disagree on the value of the property. If this occurs, it may be necessary to seek an order from the court to engage an independent valuer to resolve this dispute. Both parties must provide all relevant documents related to the property's value, including recent property appraisals, recent sales data for similar properties, and any information about improvements or renovations undertaken within each party's possession or control. As I mentioned, property has a very broad definition and includes basically every possible interest that a person can have, just looking at some of the particular examples. Bank accounts. All bank accounts, including savings accounts, checkings accounts, term deposits and any other financial accounts must be disclosed. The current balance of these accounts are also relevant for valuation. Investments such as stocks, shares, bonds, mutual funds, and any other investment holdings should also be listed along with their value. This would also include cryptocurrencies and other digital forms of currency such as PayPal accounts. Personal property encompasses personal belongings, vehicles, jewellery, artwork, furniture, and other valuable items. High valuable personal items need to be appraised for accurate valuation. If either party owns a business or has a share in a business, the value of the business and its assets must also be determined. The value of superannuation funds, which represent a significant portion of many individuals' wealth, needs to be considered, especially when dividing assets for long-term financial security. The latest member statement or a superannuation information form will value each party's superannuation and should be requested at ongoing periods until an order or an agreement is reached. If parties effectively have control of an entity, then that's going to be included as property, even if the party is a trustee of the trust or a director of the company. The court has the power to look through the corporate veil. Usually trusts and companies come within the definition of property and form part of the asset pool. Even if a party is not a trustee of a trust or director of a company, but they still have control over the trust or company, it is still an asset and the court has the power to deal with it. The important word is control. This is a quote from the case which confirms the court is not bound by formalities designed to obtain advantages and protect a party who is otherwise, for all intents and purposes, in the position of an owner. The case of Cannon and Spry is very well known in family law circles due to numerous appeals. In this case, it was found Mr. Spry ultimately still controlled the trust, and as a result, the trust formed part of the property settlement. When assessing whether a party has control over the company or trust, we usually start by requesting the trust deed and any variations to the trust deed, a company constitution, financial statements and tax returns, meetings of minutes. We then look at who is the trustee, what are their powers, who is the appointer, who are the beneficiaries, who has received distributions in the past, who is receiving distributions now, have there been any restructures or amendments to the trust deed, and if so, when did this occur, and when were the assets of the trust purchased, whether this was before or during the relationship. This information will assist our assessment as to whether the trust or company should be considered as property and within the control of the parties. Overseas property can also be included in the property pool. However, it is the enforcement of those orders in the other country that is an issue. For example, say the parties have property located in India and the orders made in relation to that property. We cannot enforce an Australian court order in India, but we still can factor it in as an asset that one party is retaining in that country. Inheritances is something clients ask about frequently. It really depends on whether the inheritance has been received or is about to be received. If the inheritance has already been received, then yes, it will be considered as property and comes into the asset pool. If the inheritance is merely an expectation that the party may receive an inheritance, it will not be included, as there is no certainty that it is going to be received. Unfortunately, the court looks at pets as being property rather than children. How is superannuation considered in a property settlement? Superannuation, of course, forms part of the asset pool. Prior to the amendments in the Family Law Act in 2002, a party superannuation was treated as a financial resource. However, since the 2002 amendments, superannuation is now treated as an asset of the parties. This means it can be split as part of the property settlement to give effect to the division of property. Superannuation is treated slightly different to regular property. For example, let's say the husband is splitting $100,000 of his superannuation to the wife. It remains superannuation for the wife, and she cannot access it until she is otherwise able to access her superannuation. Now, what happens if a party has superannuation overseas? In the ordinary course of things, we don't have the power to deal with an overseas superannuation or pension fund. The jurisdiction provided within the Family Law Act only extends to superannuation funds and pensions within Australia. In this case, we would treat an overseas superannuation and pension as a financial resource. When it comes to valuing superannuation, there is a process for obtaining the relevant information which is set out here. Sometimes it is a little bit more complicated than what is on the party's member statement, particularly when one party has a defined benefit from a military super. In these circumstances, we would normally have to get an expert to perform a valuation. Once we get the base information to do the calculation, capital gains tax and realisation costs is another one of those it depends kinds of situation. It will really depend on how likely it is that the property is going to be sold in the near future. Capital gains tax should not be taken into account as a liability attached to the property unless the sale is inevitable or would probably occur in the near future. If there's a significant risk that the asset will have to be sold in the short to mid-term, then the court may take the risk into account as a relevant future needs factor. The weight attributed to the factor varies according to the degree of the risk and length of the period within the sale may occur. In some cases, it is appropriate to take contingent capital gains tax liability or realisation costs into account. For example, if the asset has been valued on the basis of its net realisable value. Past taxation losses, which may be offset against future incomes, may be a financial resource also. Accountants play a significant role in assisting their clients in compiling this information accurately. Understanding the valuation methods and working collaboratively with solicitors to present a comprehensive view of your client's financial circumstances. This is why it's very important for clients to get advice early and often during the proceedings. The second step is to look at what contributions each party has made. It is a retrospective analysis. We assess and value both parties' contributions throughout the relationship towards the acquisition, conservation, and improvement of property. Contributions can be both direct and indirect, and they can also be financial and non-financial. Contributions also include contributions towards the welfare of family and contributions as homemaker and parent to children throughout the relationship. Contributions may include things like maintenance for a property, to maintain an asset, managing an investment portfolio, undertaking renovations on a property that someone else is doing themselves with their own labour rather than employing tradespeople. Non-financial contributions play a significant role in the property division process under the Family Law Act. These contributions recognise the valuable efforts made by each party to the relationship beyond financial contributions. Non-financial contributions are also taken into account in step 3 when we consider the future needs of each party. These contributions are sometimes equally valuable to a party's financial contribution, depending on the individual circumstances and the facts of each matter. Something that is recognised more commonly now is care provided by grandparents and also children from previous relationships. Depending on how long the parties have been separated. It is a rule of thumb that in a long marriage, particularly if there have been children, that we're probably looking at an equal assessment of contributions. It is generally considered that in a long relationship, particularly if there have been children, we are probably looking at an equal assessment of contributions, unless there is something significant from outside of the relationship. This could be an inheritance that one party received, or in the circumstances where one party brought a very significant asset into the relationship in a short relationship. Particularly if there are no children, it's much more of an assessment of their retrospective financial contributions. Funds from an inheritance or a gift from a family member or friend are treated as an additional contribution of the party who received them. Any money that was received, however, does not get refunded. The party will receive a percentage division in their favour. The court will need to consider the size of the gift or inheritance, the timing of the gift and inheritance, and how the gift or inheritance was used. Infidelity and other moral wrongs are generally not relevant to the assessment of contributions. Losses incurred by either or both of the parties during the relationship, for example, bad investment decisions, should generally be shared, although not necessarily equally, unless one of the parties embarked upon a course of conduct designed to reduce or minimise the pool of assets, or one of the parties have acted recklessly or negligently with matrimonial assets, the overall effect of which has reduced or minimised their values. Wasteful behaviour can be relevant. For example, significant funds wasted on gambling, alcohol, can be considered as a negative contribution. Serious domestic violence can also be relevant if it impacts the victim's capacity to contribute towards the property pool. So now we move forward to looking at each party's respective future needs. What this step requires us to do is look at whether there is any disparity between each party's positions for their future needs. Future needs can include their age difference, whether one party has significant health issues, the parties' respective incomes and their capacity to continue earning an income in the future, the capacity of the party who has primary care of the children, how long the marriage or relationship was, and what was the impact of the relationship on that party's career. Has one party put their career on hold to support the other party's career? We often see this in parents who take a period of maternity leave from the workforce to raise the children, whilst the other parent continues to earn an income. Generally, if one party is worse off than the other party when comparing the Section 75 subsection 2 factors, then the court may make an adjustment in that party's favour by giving them a greater percentage of the property pool available for distribution. The principle behind it really is that, again, we try to finalise the financial affairs between the parties who are separated. The payment of child support in no way compensates the custodial parent for the loss of a career opportunity, the lack of employment, mobility, and the restriction on an independent lifestyle which the obligation to care for children usually entails. A short life expectancy, whether relatively certain, can be a factor that the party has limited future needs. Lastly, we look at the overall percentage in which we've arrived at. We do this by looking at the contribution factors and the party's future needs. We then consider whether it is just and equitable in all of the circumstances for a division to be made to the property pool. Okay. As I mentioned before, we recommend our clients to get advice from their accountants, certainly in cases where they operate a business, particularly through a company or trust, or have a self-managed super fund. We also recommend clients obtain financial advice in relation to their tax and accounting implications on the proposed settlement, whether the proposed terms achieve the desired effect, and whether to retain the trust or company structure to their benefit. The last thing I want to touch on today, which is the number one thing a party can do, of course, is getting legal advice at the earliest opportunity. Whilst every case is different and everyone knows someone who is separated, each situation is really different, and it's important that clients obtain preliminary advice in this regard about what their entitlements might be and how best to move forward. It is important for parties to be informed before they move ahead, in particular what their position is and what their entitlements are. Some practical things to consider moving forward are having your clients obtain preliminary legal advice, reviewing their will or estate, staying in the matrimonial home if possible and trying to keep it, limited liability in terms of their mortgage or credit cards, collating and protecting their important documents, changing their passwords and PIN numbers and redirecting their mail, photographing valuables, and storing sentimental items off-site in a safe space. If the parties are living under the same roof, it's important to negotiate appropriate boundaries and move forward with a plan. That is everything that I wanted to cover today. Hopefully we've provided you with a brief summary of what's involved in a property settlement, the kinds of things we look at, and how we try to help clients resolve that dispute. Thank you for joining me this afternoon, and we're happy to answer any questions by email if you think of anything down the track that you're wanting to know a little bit more about. Otherwise, thank you very much for your attendance this afternoon.